So just to sort of wrap it up relatively quickly, what happens is DOJ indicts him on a human smuggling case, not a human trafficking case. And those two terms are not interchangeable, as the magistrate in an order granting conditions of release made very clear. The human smuggling case is generally a cooperative arrangement between the smuggler and the smugglee.
Right.
It,
It's not legal just because people agree to be smuggled.
right, but it is not. But as the court noted, human trafficking is an exploitative relationship.
Yes. It's even worse. That doesn't make the smuggling legal.
No, but the smuggling is not a crime of violence that
Right.
it triggers the right to a detention hearing.
Right.
Okay, so what happens is he gets indicted on three counts. I think one count of conspiracy and two substantive counts of human smuggling. The indictment relies upon a collection of cooperating individuals, likely other Trinidad. No, he's not. He's an MS-13. Other MS-13 members involved in the operation at some point in time, moving illegals from. I think they generally were talking about the general southeastern Texas border and south of Houston with Mexico, and then up into the general Baltimore area where they would, disperse to, the four corners of the compass. Um, and this, according to the indictment, went on over a significant period of time. I think that I might have read somewhere as many as 90 individuals, but then again, that could just be, my mind being numbed. Um, so, it is according to the allegations of the indictment, a conspiratorial arrangement, long-standing, significant financial benefit that he's alleged to have been involved in during the just be, my mind being numbed. Um, so, it is according to the allegations of the indictment, a conspiratorial arrangement, long-standing, significant financial benefit that he's alleged to have been involved in during the 6+ years that he, was a dad living in Maryland.
Right.
So on the basis of that indictment, they bring him back from El Salvador. We've got this Judge Zenas,
Zenas. Yes. Paula
Zenas
Zenas is how she
in
pronounces her name.
in Maryland, who has been demanding his return to the United States going back to late March or early April, um, and finally. Now, there's been some, Andy McCarthy and I disagreed some in writing on, the what what could have been expected in an indictment given the time that passed. And my point was, I wouldn't have expected a lot in an indictment of that nature after just 7 weeks starting from scratch. And there's not a lot in the indictment, but once they had what they thought they could get past a grand jury, charged them with the three counts in an indictment, three felony charges, they asked El Salvador to release him and send him back, and El Salvador did. But they
Just to
didn't
make
send
it
him back.
clear for any listener who's not like totally up on who we're talking about, this is the guy who the mainstream media characterizes as having been wrongfully deported to El Salvador.
Correct.
Right.
He went through immigration proceedings in 2019 and was given an order of removal, and then he applied for relief from the order of removal. He's an illegal alien, had come to the United States in 2012, had a whole story about how that happened that reads like a crock of crap, but um, and so then he applied for what's called withholding of removal, which is to prevent the order of removal from being executed, and it was granted as to the country of El Salvador. Now this is in 2019. Don't have to go into the long backstory, the reasons why he was granted withholding or removal for El Salvador, but or the rabbit hole side story that the judge referenced Guatemala in his order of withholding of removal. That's a rabbit hole. Um, but so he's granted withholding of removal to El Salvador. Everybody
Which is
has
where
taken,
he's from, right?
which to his home country. He's a citizen of El Salvador. So um, nothing nothing happens because when your home country won't take you back, it's sort of stymied. The option is the illegal alien who has been ordered to leave can voluntarily arrange for his own deportation. So, for example, if France would give him a visa, he could get the United States would let him get on an airplane and go to France.
Right.
Um, or if he cannot arrange for his own departure from the company or is unwilling to provide proof that he's arranged for his own departure to his own departure from the country,
Country.
he can't. He is subject to being involuntarily removed by ICE.
Right.
Now, there are some conflicting rules in case law about how long somebody can be held in custody pending removal if there's no substantial likelihood of removal in the foreseeable future. In other words, there's case law that says you can't just take an illegal alien, throw him in jail
And
simply
forget about it
because,
because you can't figure out where to send him to.
right, because their country won't take him back. You have to, so on that basis, Abrego Garcia was granted bail. I don't know if that's what they actually call it. He was released from custody, and he had certain conditions which really amount to don't violate the law, which apparently he never did. He has no criminal record, and check in with ICE once a year, which he apparently did. There's a record of him checking in with ICE once a year going back to 2019. So, but the Trump administration and so the Biden administration from 2021 to 2025 had no interest in him. And he became Maryland dad, got married, has two kids. But now the allegations in the indictment are he's been engaged in this illegal activity with members of MS-13, and there's a dispute whether he's a member of MS-13 or not. I'm knowing quite a bit about MS-13, having prosecuted cases in Central California for 10 years where there's a very strong presence of MS-13. I've got a pretty good idea that yes, he is, and MS-13 is notorious for using juveniles to actually commit the crimes,
Right.
and the older members are the shot callers but never get their hands dirty. So the fact that Abrego Garcia in his late teens and early 20s has no criminal record does not surprise me at all.
Right. Now it's not been proved in court that he is a member, but
well, there's kind of an art to gang identification based upon tattoos.
right.
And what is necessary to understand is that these gang members, they take these tattoos as a matter of pride. They're
Right.
not hiding them. They're not trying to disguise what they are. It's exactly the opposite. The tattoos are to identify yourself to other members of your same gang that you don't necessarily know as being one of them, and at the same time to warn members of other gangs that you're a member of a rival gang and to leave you alone. So these gang membership symbols in the form of the tattoos, there are entire industries in corrections, whether it be
Yeah.
the state of California or the Federal Bureau of Prisons, where gang identification is critical because if you put a gang member in the wrong location with the wrong gang members, you're going to end up with
You
dead
have
gang
problems. Okay. And I'm on board with all that. I'm just saying that to be fair to him, it's never been
members.
proved to a judge that he is in fact a member, but there's like a lot of indicia.
Yeah, but there's not really a lot of opportunities, particularly in federal court, to prove
Right.
somebody's a member of a gang, and particularly not on an immigration basis. And this kind of became something that I faulted Judge Zenas over. Is she was making some. It's like, when does a federal judge ever have to make an issue out of gang identification? You don't do immigration cases, and so okay, so that's
Well, she was in the
we're on a
public
tangent.
defender's office there for a long time, so she herself might actually know quite a bit about that as well. So
All right,
that might
well
be
that's
why
it.
she gravitated there.
All right. Well, we're on a tangent, so let's get off
Yes.
that tangent. Okay. So what happens was, so the government brings him back, and Judge Zenas up in Maryland has been waiting for the government to bring him back, and this kind of raises a question that is now pending in that court: is that why does she still have a case? Because the relief that was requested in the complaint file, the civil complaint filed in the District of Maryland by him and his family, was that he be returned to the United States.
Right.
Mission accomplished.
Which he duly has been, except he's been jailed.
Right.
He's been charged. Yeah.
Right.
Right.
So the government has a motion to dismiss on the basis of mootness pending before her that the opposition is due Monday. We'll get to that in a moment.
Yeah.
So what happens though is that um, Abrego Garcia's criminal defense lawyers in the Middle District of Tennessee, where he is charged, file the government seeks detention, and they file a motion for release. And there is a evidentiary hearing. I think it was an evidentiary hearing. There's an evidentiary hearing on the motion for release before the magistrate. It's there's some aggressive arguing on both sides, and the magistrate on Tuesday or Wednesday of this past week issues an order granting release based on terms and conditions. On and I read it. It's actually, I think the order is correct, because you can help me off the top of my head here as I go along, but the factors for release pending trial are the nature of the offense. Well,
Right.
she said, look, this is human smuggling, not human trafficking. It's not considered a crime of violence. The victims are really the government of the United States, not the people being smuggled. They're actually in a cooperative venture with the smuggler. There were some allegations that he had minors in the car, maybe including his own children. She just there was a semantic debate in her order about what it meant to involve minors.
Right.
And she found that that the government's evidence did not meet a sufficient standard or definition of involved to trigger even the entitlement to a detention hearing. Not all federal charges uh, provide the opportunity for the government to seek detention.
Right.
Depending on the nature of the charge, the government's not even allowed to ask for detention pending trial. And she ultimately concluded that the circumstances here were such that the government was not entitled to a detention hearing. But then she went alternatively to say that even if she's wrong and the government is entitled to detention hearing on the merits, she thought that there were terms and conditions of release that could mitigate risk of flight and danger to the community. So the risk of flight issue, she recognized, and this was, I kind of mocked this online because so many people were, pounding their fists over
Oh,
how could
losing
she
their
let this
minds
happen.
because he got released, but
Yeah,
it's because they don't understand the system.
but right at the first paragraph of her order, she said one thing the defense and the government seem to agree on with the court is that even if ordered released here, in his criminal case, he's not likely to ever walk free because
He's
he
not
will
going
go into
anywhere.
ICE
Right.
custody.
Right.
He has an ICE detainer hold on him if under the Bail Reform Act in the criminal case it is not appropriate to hold him in custody. She ordered him released, but everybody understood that he would simply go from the custody of the U.S. Marshal to the custody of the Immigration and Customs Enforcement. It was
Right. And
just
this is common, especially in areas, probably other areas of the country have this too. But like in the Maryland, D.C., Virginia area, the states are very close together, right? So often you'd have clients who, okay, he might be eligible to be released on this charge in the district, but he's got a pending charge over in Prince George's County. And so he's not going anywhere, right?
right.
Because Maryland has lodged a detainer saying if you release him, turn him over to us because we got charges for him. So this happens all the time.
Yeah.
And the people don't understand because, of course, why should they? They're not in our line of work.
Right.
But so people understand, the criminal judge doesn't really care in one sense what his immigration situation is. Like, that's not a factor in her decision making according to the test, right? As a practical matter, as you just said, she's like, he's not really going anywhere anyway. But what's in front of her is supposed to be with what he's charged with in federal court and what his circumstances are. Is he a danger to the public, right? Boiling it down, danger to the public, and is he likely to come to court when his case is called?
Right.
So,
So on
that's all she has to
subject,
decide.
she said, "Well, I can't find he's a flight risk because if I order him released, he's going to go into ICE custody.
Right. Yeah.
So he's not going anywhere."
Right.
So she found he's not a flight risk. So then the question is he a danger to the community? Well, you have the same problem. He's likely not going anywhere. But even if he were to be released by ICE, she said he's got no criminal record. Um, he has ties to the community where he lives. I don't think he had a history of employment, but it was the kinds it was the kind of findings based on the facts that were, they don't necessarily make you happy when you hear them, but it's kind of
Yeah.
hard to take too much
But that,
issue with them
but
as a prosecutor.
if he wasn't a famous name, that would have been the right outcome. Like
Exactly.
that happens tomorrow in somebody else's case. Same facts.
But all she is reviewing, she is, like you said, she's got little or no actual consideration of his immigration status. She's looking at under the factors of the Bail Reform Act, is it permissible or not permissible under the Eighth Amendment to keep him in custody? It's an Eighth
Right.
Amendment violation to keep somebody in custody when there's not a basis to do so. It's
Right.
excessive bail. So
And
she
just
is.
so people are clear, the she that we've been talking about is not Judge Zenas. It's the
This is the
female magistrate in Tennessee that we're talking about now.
I think Judge Barbara Holmes, is a female magistrate who has been a magistrate for a long time. I think like 10 or 12 years.
Okay.
It's not a rookie at this, and so one of the things you have to understand, if those of us that have done this work, for a long time, a magistrate judge in Tennessee after 10 years of serving that role has probably done 10,000
Oh my God, they've
petition
seen everything. Yeah.
Exactly.
Right.
There's nothing. There is no new issue under the sun,
Right. Exactly.
and there are few unique facts that they've never had to consider before. They have a whole spectrum of experience about where the line is for release and where the line is for detention, and it usually doesn't take a lot for them to figure out which side of the line the defendant falls on.
And this
And
magistrate did a good job because she made both findings. She said, I don't think the government has the right to ask for it, but even if they do, I find that the burden isn't satisfied.
right.
So she's covered all the bases.
So now the
There.
government is entitled by statute to
Mm-hmm.
appeal that
To appeal
decision
that.
to the district judge. The district judge is the Article 3 judge appointed by the president. The magistrate judges are simply worker bee judges that are hired by the district judges to take some of the workload off them and handle things like bail reviews. And in fact, I saw commentary online from, one of my favorite legal analysts slash, private chefs that,
Who shall remain unnamed on this
how does
podcast?
this magistrate judge, not even appointed by the president, have the authority to blah? It's like,
Oh my goodness.
well, it's like there's a thing called the
Because she
Magistrates
does have the
Act,
authority, right,
and
given to
and
her
the
by the Congress.
and the bail review statute talks
Right.
about magistrate judges entering bail orders. So,
Right. Yeah.
um,
Well,
you
there
know,
you go. Somebody who doesn't know what the law is. So,
right. So,
although pretends to.
yeah.
So,
So then they appeal to the district court judge, who happens to be an Obama appointee.
okay.
And I mean, he issues an opinion affirming the magistrate judge's release order, and it's like, okay, well, the release order is not beyond the pale and unreasonable, so he affirms it. I'm not shocked, and
Right.
everything is, as a prosecutor, you probably want to try to keep him in custody if you can, but sometimes you recognize it's just not in the cards.
Right.
So, but here's the kicker. So then Steve Miller goes on TV. Stephen Miller, Deputy White House Chief of Staff, goes on TV and says, well, when this is all over, we're just sending them back to El Salvador anyway.
Right. Great. Thanks, Steve.
So then, now knowing that he's going to be released in Tennessee to ICE custody, the plaintiffs, his family up in Maryland, go barreling into Judge Zenas and say, we need an emergency order from you that he be transported, if released to ICE custody, that ICE bring him to Maryland so that you can have him available to preserve jurisdiction in your case. So they
In
have
her case, that's over.
in her case, well, it's pending. Motions to dismiss are filed, but there's, she's got some outstanding motions for sanctions for discovery violations. She's been just irrational on the case from the start. And so she has things still pending, before her.
No,
And
but I mean the relief that they wanted, that he needed to be there for, they got. He's here now.
yeah,
Right.
exactly. Well, they've got the relief they prayed for. But they wanted her to order ICE to transport him if he's put into ICE custody, for ICE to transport him and keep him in Maryland in preservation of her jurisdiction. And so what happens though is, so there's
Mhm.
an immigration litigation attorney comes to the hearing, or it may have been on. I listened to this hearing. It might have been on a Zoom call, and
Okay.
the public line was open, so I'm listening to it. And she, right off the bat, she says to him, "Well, I can't remember his name, Mr. DOJ lawyer. Before we get into the merits here, let me ask you a question, because this is going to maybe influence significantly the schedule that I adopt here for some things that are proceeding. We have the release order in Tennessee that is supposedly going to be was supposed to be effective yesterday. I don't know what it ended up. Oh no, I do know what happened. We'll get to that in a minute. And I think this was on Thursday. Sorry, it was Thursday. So, can you tell me what you expect to happen
Hmm.
if that release order goes into effect and he's transferred to ICE custody?" And the DOJ lawyer says to her, "He's going to be put in removal proceedings."
Right.
And so
Because what do they want to do with him? They
right
already said he should be removed.
now it's only Steve Miller who has said that he's going back to El Salvador, but we still
Right.
haven't cleared up the problem of him having withholding of removal to El Salvador. So
Right.
sending him back to El
Right.
Salvador
Because
again.
Steve Miller is
Exactly. Who's
not
not a
completely
lawyer.
on top of this guy's case, and he's
And
not a
he's
lawyer.
not a
Right.
lawyer. So and Steve Miller is just responding to an inquiry from the press, and in his bomb throwing fashion, which he does that. There's a purpose behind
Right. He hasn't
what
read
he
this guy's
does.
file. He doesn't know, well, actually,
Right.
we can't send him back to El Salvador. We got to send him somewhere else.
So so then the judge says, "Well, do you have any time frame for when that might happen?" And the DOJ lawyer says, "Your Honor, I don't." She said, "Well, does that mean it could happen anytime between 30 seconds and 30 days after he goes into ICE custody?"
Right. Yeah.
And he says, "Well, all I can tell you is I don't believe his removal would be imminent." And
Right.
she said, "Well, can you say where his removal would be to?" Raising the issue of, El
Hmm.
Salvador is still problematic. And she said, and I think she said to El Salvador or someplace else. And he said, to a third country.
Right.
Which raises the specter of South Sudan
Right.
being
Yep.
a
Yep. Our,
possible
our trusty
destination.
friend South Sudan now. Right. Yeah.
Right. So so now, all I could just barely hear the ACLU lawyers who are I don't not ACLU. It's a big law firm. Quinn? What's the law firm that starts with Quinn?
Got
Quinn
me.
Quinn
I stopped.
Sullivan.
Yeah, that sounds right.
Yeah. So the lawyer from Quinn Sullivan is representing him. Starts, "Well, Your Honor, this shows why we need an emergency order from you to block that and to have him brought up here for purposes of preserving under the Raw Writs Act for purposes of preserving the jurisdiction in your case." And
I'm
she
not following
basically,
this though. To what end?
well, the case is still live. It hasn't been dismissed. They have sanctions. They want to go through.
And he needs to
Who
sit
knows
there in
what they?
court,
Well,
right? He needs to
apparently,
sit there and observe
right.
those hearings. That's
So, but
absurd.
but she starts kind of in a roundabout fashion saying, "Well, the remove or the release order in Tennessee is problematic. Have you been in contact with your counterparts down there?" And the guy says, "Well, we do not represent Mr. Vega Garcia in his criminal case in Tennessee. I'm familiar with it. I've spoken to his counsel, but I'm really not in a position to say anything about the events taking place in that case." And she says, "Well, it seems to me that maybe you should get with his criminal defense lawyer and talk about the wisdom of the release order."
Right. Since they were the one that asked for it.
Right. And and, and so then she starts talking about it, and she says, and he says, "Well, but if it happens as early as tomorrow, then we'll probably need something from you quicker than that." And she, over the course of about 15 minutes, she said, "You're not going to get anything quicker from me. There's a motion to
Right.
dismiss here on the
Right.
basis that this case is moot."
Over.
And
Right. Yeah.
she said, "I'm going to, before I do anything, I'm going to confirm that I still have jurisdiction." She said, the opposition papers for the motion to dismiss are due next Monday. She said, I'm going to accelerate the hearing date. We're going to set the hearing date for July 7th, which is another week away.
Right.
She said, but I'm not going to, issue orders in a case where I'm not confident I still have jurisdiction. So maybe you should discuss the wisdom of the release order
Right.
with
There's
your
another way to skin
counterpart.
this cat. Maybe you should talk to Tennessee. Right.
Right.
Yeah.
So,
Well, what I
so
can tell you, I've appeared in front of Judge Zenas. She is very, very, very smart. Right. And I would guess that her politics are on the left. A lot of the Maryland judges are on the left, but she is no dummy at all.
Well, my criticism of her from early on was that she simply adopted in all of her paperwork the facts as set forth in the complaint, even after they started to unravel,
Hmm.
and has proceeded from that basis. So, based on the fact that the government conceded that it was a mistake to send into El Salvador, then everything the government says is suspect, and everything the plaintiff and his family
Hmm.
say is gospel.
Well, she was a public defender. She was a defense lawyer for a long time. I have no doubt that she doesn't trust a lot of the government's representations.
What ended up happening was yesterday, and this is something I posted about that I've got a little bit troubled by. Yesterday, the defense filed a motion to delay the effect of the release order until July 16th, which is a week after or 10 days
Right.
after the hearing on July 7th, where she's going to determine in Maryland whether she
Super
still has
convenient.
jurisdiction.
Right. Super convenient. It's a convenient day. The 16th sounds good. Let's
Right.
pick that day.
Yeah. But what happens after that is what kind of has me scratching my head. The government said they didn't object, that he could remain. So in fact, the government just went along with it. Okay, we'll
Right. They
wait
just don't want to
until.
fight about it. They got other things to
Right,
do.
right,
This
and
guy's not going anywhere except to South Sudan, and that's happening shortly. So why are we wasting a lot of time on this?
right. But as a substantive matter, I've got a little bit of an issue with that position because keep it until the 16th strikes me as a violation of the Eighth Amendment. There's already
Well,
been a
and
judicial
I don't know
ruling.
what it's an Obama judge you said down in Tennessee. There are judge.
Yes.
I've appeared in Tennessee also. I had one for 1 3 year period. I had 3 or 4 criminal matters in Tennessee. It was one of the few other states where I practiced, but so I know a little bit about the courts down there. And there's quite a few judges on that bench that I think would be saying, "What is this? A fraud on the court? You wanted him released, now you don't. The government doesn't care. They wanted him detained. Like, what's going on here? You
Well,
can't just come in here and change your position just because without any real basis."
yeah, it's. I don't think it's so much a fraud of the court as it is this court has already ordered. There's no legal basis to
Right.
detain him,
Right.
and you're asking us now to keep him 3 more weeks
Right.
in
Not based on
violation of
new
law.
facts. Not based on new facts that go to the factors that the
Right,
magistrate judge considered, but on other stuff.
right.
Yeah.
But so far as I know, as of yesterday, the two sides had agreed, and he was still in Marshall's custody and not transferred to ICE custody for
Right.
initiation of removal proceedings.
Well, I was being
Uh,
sarcastic before, but don't you think that's what the government is thinking? Is like, geez, Louise, let's just get this over with. Why do we care?
Why did they wait 3 weeks?
Because Judge Zenas in Maryland is going to have a hearing on July 7th, and she might find that she has jurisdiction and then order some or enter some order under the All Ricks Act that he not be removed from the country.
Right. They're hoping for that home run. Yeah. I'll be surprised if she gives them that order because I understood why she, especially this judge, she's on the left, but she was a public defender. She is very focused on like the rules have to be adhered to, right? The government can't do things is not per the rules. So I can see why she was upset with the removal to the country that he specifically got basically a waiver for, right? But now that he's back, and if they're going to deport him on other grounds, I'll be real surprised if she tries to get in the way of that.
And I think she does have to. She can't ignore the fact that in the sequence of events, they did pull him out of CCOT, that
Right,
notorious El Salvador prison. He
right,
he did. He met with Van Hollen.
right,
He told Van Hollen he was fine, that he was not being abused in any way, that he was comfortable where they were keeping him. And 45 days later, he's back in the United States. He's facing
right.
criminal charges, but He's only facing criminal charges because that video from the Tennessee State Police surfaced.
Right.
Where he's got 9 Hispanic males in the car heading to a construction job, but nobody has any tools or luggage.
Right. Yeah. Yeah. Okay. That reminds me, there was an old statute in Maryland. Well, it was a common law charge, actually. When I first started practicing law, it's been disavowed now, but it was the charge of failure to do right. And basically, people got charged with that if a cop came upon them and the guy had burglar's tools on him, or tools or devices that you could use to like pop the ignition out of a car and steal cars.
I think
So
there are statutes now in many states that have that certain kinds of instruments can be subject to a misdemeanor.
right. Well, none of these things were illegal to have, right? And there was no evidence that the person was, like in the process of stealing a car. So, that somebody just came up with this. Literally, this charge was failure to do right. Okay. So, yeah, so those dudes, they didn't have their failure to do right tools on them. That they had, then maybe that would have turned out differently. Well, okay. So, that case is going nowhere in a hurry, right?
Well, I did make a prediction before they came to the deal on Friday, to postpone the effect of the release order until July 16th. I did post on X a prediction that by next Tuesday he will be either back in El Salvador or in South Sudan, his choice.
Right, because he could withdraw, right, his objection to going back
Exactly.
to El Salvador. Mm-hmm.
Exactly.
And maybe he will, having been there and decided, well, maybe it's not as bad as he was afraid it was going to be.
Well, he doesn't have any assurance that Bukele, the president, won't throw him back in SCOTUS as an El Salvador citizen.
Yeah, right. Who's been convicted of crimes up here or charged with them or whatever. And then what? The government will drop the charge in Tennessee then, right?
Right. It's like, there was some, hand wringing from people about, well, could the government act deceitfully and just remove him from the country and defeat his rights to defend himself? It's like, well, there's this thing called Rule 48.
Oh, yeah.
That when the government takes a step to make it difficult for somebody to defend themselves, you just dismiss the case.
Dismiss that case. Most of the clients I represented would have been thrilled to have their cases dismissed. Right? Now, usually that's what they're going for, actually. So, okay.
Actually, there was an interesting representation by the this might have been in this might have been in a press conference, or maybe it was in the oral argument of the detention hearing in Tennessee, where the acting U.S. attorney down there sort of kept going out of his way to say, well, I can ask ICE to keep him in the country, but ICE is that's a different department. They're not part of the Department of Justice, and I really can't. I have no authority to compel them to not ship him out of the country.
Right. Okay. Oh, good grief. All right. So, but big picture, that case is going to get sorted out. He's going to be removed because he's not going to be released by the Trump administration onto the street again.
Right. He will not enjoy any form of liberty in the United States because he is an illegal alien with an order of removal. He will either sit in detention,
a pending criminal charge.
Right. He will either sit in detention or he will be deported, and he might be given a choice to go back to El Salvador or, take behind what's door number 3.
Right. Yeah. Yeah. Probably he will think that his home country is a better bet than South Sudan. But, that's up to him. Okay, so let's do the updates on the other cases first, and then we'll talk about the Supreme Court cases. So I did a quick look at some of these ones we've been talking about recently. No update on Senator Padilla. I'm going to keep bringing this up. He's not been indicted yet, you guys. So another week, he's safe so far. Congresswoman MacIver, also no update in her case, in the legal case, except that new video surfaced going around. Did you see this, Chip?
Is that the reference? I may have seen your reference to it
Might
about
tweet about it.
I'll shove whoever I want to shove or something
Yeah,
like
I touch whoever I want to touch, motherfuckers. I'm quoting the congresswoman. So, I think that's going to be a problem for her
Yep,
at her
yep.
trial. Certainly, if the J6 model of prosecuting people holds up, the government will use that against her because she's still on the scene, and the officers are telling her basically keep her hands to herself, and that's her response. So that was interesting. But that case is still in pretrial proceedings, as we discussed a few days ago. Also, no decision yet from the Second Circuit on the president's removal case there. King, am I right about that?
That's right.
Okay. Wisconsin judge's case also is sort of on hold. They're doing pretrial stuff, and that trial judge there is trying to decide whether to dismiss or not. On the Maryland standing order kerfuffle, this is a case where the DOJ sued all of the judges in Maryland, including Judge Zenas. She's got a lot of things to deal with at the moment. And they that also filed a motion basically to recuse all the judges and have the district court clerk work with the Fourth Circuit to find a judge that's not in that district to handle that case. And I couldn't understand really how they thought the judges could all recuse themselves, but somehow the clerk couldn't or shouldn't. The clerk is a defendant just as much as the judges. So, like, nothing happened for a day. And then Friday, I guess, could have been Thursday, but I think it was Friday, Judge Russell, who's the chief, issued an order on his own signature that just says, we got this complaint and there's this request to recuse all of the judges. And so I'm sending this case to the Fourth Circuit for them to rule on all of it, basically. It seems to me that the chief just stepped in because he didn't want the clerk to do that. The government had asked for the clerk to do it, but Russell just jumped in there and said, I'll take care of this. I'll ship it to the circuit. And then I checked.
Except the Fourth Circuit doesn't have jurisdiction to rule on all of it.
Right. I don't know. Well, I don't know who's going to rule on this, but as we discussed, it's not a real lawsuit anyway. So there's so many problems with it. But I looked today and okay, so Judge Russell's new order basically says, I hereby refer this case to the Fourth Circuit. But the Fourth Circuit has no docket for this case yet. There's no number. You can search for their names, it doesn't come up. You can search for the district court number as the referring number. No docket comes up on the circuit. So probably the clerk's office and the chief there are trying to figure out what to do with this. And King, you may be right. They may be like, we can't do anything with it either. We'll see.
They can assign. I think they have
Yes.
the power to assign a judge, but that's it. They cannot comment, rule, dismiss anything. They
Right.
just they can assign a new judge if because of conflicts and
Right.
whatnot.
Right. They have a procedure existing for doing that, which is what the government was trying to invoke with that motion. But rather than let the clerk deal with that, Russell said, okay, I'll send it to the circuit. So, Richmond, you guys figure out what to do with this. So that's where it stands as of now. Um, in the Massachusetts case, where the judge there, the new judge up there, is struggling with this question of third country removals that we talked about at length last time, there's no new entries on his docket that relate substantively. There were two new entries, but they both had to do with what interveners coming into the case, basically the media. I'm not quite sure. I didn't look at that angle. Why the various media organizations are trying to intervene in that case? Maybe because he's, I don't know, partially sealed some of the docket or something. But there's a couple of entries about that, but nothing, no new moves, and also no move yet from the Supremes in response to the Solicitor General's, Mr. Sowers' request for them to clarify to this judge what he can and cannot do. So, do we think that the Supremes have said they're going to have their their orders day is going to be Monday, the 30th, so the day after tomorrow, I guess. Do we expect to see that ruling on Monday then, do you guys think?
Well, there's the court posted yesterday that there would be an orders day on Monday and maybe another one I think on Wednesday. There's possibly one now.
Okay.
Now, obviously, historically, an orders day means they issue orders granting cert in a collection of cases that will start them off in the fall. If yes, I guess some have probably already been, but without any more explanation, I need somebody who's got a little more experience in tracking this stuff over the years. I mean, they obviously have a couple of dozen motions still pending.
Yeah.
And so I just kind of assumed orders day would include those as well. They would clear the shadow docket.
Right. Right. I think that is the plan, and sort of scoop out all of their caseload except for like new incoming matters, because they get motions every day, for one thing or another. I want to appear pro hoc, or I want to have somebody appointed, or whatever. So yeah, but these seem like more like cleaning up the tail end of the term rather than ongoing business, right?
Yeah, and I don't
That
know, historically whether they will continue to issue orders on things like motions for stay all through July and August and September, where that's just like an ongoing process, or if basically at the end of the term they try to clear as much of them up when the term ends, and they'll take up new ones as they get filed.
Right. That basically is what it is. I mean, it's not completely seamless, right? But yeah. So, because they have, they don't really take the definite break, the clean break that they used to take, in the summer for the end of the term. So, but that's because of the modern way that litigation is practiced. So, okay, and then the last thing I have, I think, let me check my list. The last thing I think is the Newsom National Guard case, which when we talked last, I don't think Judge Breyer had issued his most recent decision that he was going to allow discovery, expedited discovery on the posse comitatus issue, right?
Yeah, I have to admit I didn't read the order. I know that he granted discovery. I didn't see if he limited it in any way. The government had objected to the scope
Yeah.
of the discovery as well as the discovery itself. And then I at least saw reported. I didn't read the order that he denied without prejudice the motion to transfer the case to the central district. So
Right. He
I,
did order some depositions could be taken. So, but on an expedited basis. So, um, you know,
yeah,
that's another case that's going nowhere in a hurry, I
yeah. I
think.
mean, this is I almost think this is just sort of like a thumb in the eye of the Ninth Circuit a little bit because he knows they're not going to step in on this likely,
Yeah.
or if they did, it wouldn't be in time. Um,
Right.
and ultimately, I think he's confident that no matter what he does, I mean, if he tries to, grant a preliminary injunction based on PCA, he's going to lose that as quicker than he lost the other one.
Right. Right. So that's what I'm saying. It's this case going nowhere. Eventually, the lawyers are going to come up with some face-saving mechanism for getting rid of that dog, and then it'll be gone. So, okay. So that just leaves us, I think. Let me look at my other list with the. I thought we discussed two of the Supreme Court decisions yesterday. The one about the universal injunctions, of course, and then the religious freedom case. And then we can dabble with a couple of the others if we have more time. But we've been going 50 minutes now, so this will give us a good chunk of time to talk about these two. Which one you guys want to do first? King, have you got a preference?
uh, I don't care except when we talk about the universal injunction. I want to give a gold star to Ship for writing an article for which is the first one I've noticed that caught that Justice Barrett was the clerk when Justice Scalia wrote a case on a similar issue
Uh
in
huh.
1999. That's
Okay.
incredible, Ship.
That was the year she clerked. Okay, well,
Yeah,
good.
it's a Guapo Americana versus some holding
Hmm.
company case that it's
Great.
cited extensively. It's cited extensively by her in the opinion,
Right.
and I
Because
just
she's super duper familiar with that case.
right. Well,
It
I
it
didn't.
it 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 used the same analysis,
Yeah,
Yeah.
the beginning to end, and Ship caught it. I'm impressed.
yeah. I went. Well, the first thing I wanted to read it. Okay, so this case seems to be pretty important, so I just pulled it up real quick. Guapo, and the name is kind of distinct. It's a Mexican holding company, and the facts are pretty simple. But and I just as soon as I pulled it up, I saw, oh, it's a Scalia opinion. Okay, so that's
Hmm.
why this is important. It's a Scalia opinion from right in his prime, 99, and then I thought 99. When did she clerk for him? And
Right,
I
exactly.
just went
How old
to
was she?
I
99.
yeah, I just went to Wikipedia, her Wikipedia page, and she clerked for him in the 98-99 term.
Okay. So she presumably drafted some of that opinion,
Yeah,
right?
or did
So,
research, or had probably had some role in it at some place,
yeah.
Yeah,
and because what well, so this kind of you know completed the circle because I was scratching my head over the fact that Roberts gave that opinion to her. It's like
Mm. This
that
might explain why. Yeah.
exactly. I think a lot of things explain why. One, they turned her loose to go after Jackson.
Yeah.
And I think Robert's view was, I can't have Alito or Thomas go after Jackson.
No. Right. That's not a good look,
Um,
but he
but
can do it.
having her go after Jackson is and rehabbing her a little bit with the malcontents in the conservative legal circles over some of her jurisprudence.
Right.
Um, and then it's like, oh, and by the way, she knows the subject pretty cold.
Right.
yeah,
And I was
but
and what I also I wrote and I may have commented on it on X too, but King has read it. As I was reading that, I kept having flashbacks to reading law review articles. It's a
Yes.
very
That's what it
scholarly
sounds
approach.
like. Yeah. Yeah.
just so everybody can understand, the the Guapo. How do you say that,
Guapo
Ship?
Mexicano
Guapo Mexicano case was a case in which a creditor who was owed money, but had not, and the debtor was in default,
was going out of business. Was
was going
rapidly
out
headed
of
out of business,
business,
but had assets.
and, and had assets. That creditor, before going to court and getting a judgment, talked the district court into giving him an injunction to prevent further dissipation of assets, so there'd be something left to pay the judgment
Because
with.
usually you have to
Mm.
get your judgment first before you can freeze people's assets.
That's right,
Right,
and
because the assets in question, there was no security interest in them.
Right.
There's no
he
priority
was
to
an
the creditor.
unsecured creditor like
Right.
everybody else.
Right.
So and the Supreme Court, Scalia said, the way we analyze this is an purely equitable remedy. There's no statute, there's no law that gives you, no written law that gives you the right to do this before you get a judgment. So it's a matter of equity, matter of fairness, and to decide whether the courts have a authority to do that. We go back to 1787 and 1789. And 1787 was the Constitution. 1789 was the Congress's passage of the Judiciary Act of 1789. That established district courts, and it gave them certain authority and certain jurisdiction over certain kinds of cases. And the issue, and Scalia wrote an opinion for the nerds in the legal world to beat all
Right.
nerds of the
Right.
nerdy case law, and it just it it made nerds, uh, legal nerds, just you get goosebumps reading it. And what it said was, we got to go back in time, and we have to look to see not what was going on in the United States in 1789, but what were the courts in England doing? Did they have equity power to enter
Of
that
this
kind of
kind. Of this
order?
kind. Yeah. Right.
Yeah. And Scalia, and I'm sure uh, Amy Coney Barrett did the research, and she looked up the English cases,
Mm-hmm.
looked up the English history, and found that no, they didn't have that authority. No, there was no such case authorizing that kind of relief. And
Which
so,
should have been pretty clear and obvious, I would think, in 1999, since basically no one was doing it in 1999.
exactly. So, uh, and but it that's how you do law.
Yeah, it is.
It really is how you do. That's how you're taught to do law. And if it requires going back in history, if it requires you looking at English law from way back then, you do it.
There, an interesting point for East Coast lawyers. So, for example, the Constitution of Maryland guarantees Marylanders all of the rights and benefits that they were entitled to as citizens of the English crown, are incorporated expressly into the Maryland law, because the Maryland courts of appeals long predate the Revolution. And so they wanted to, make the point that you're going to have all the rights and privileges and, whatever that you had as Englishmen, from the state of Maryland. So I don't know if the Western states do that so much. Chip, do you happen to know if the California Constitution has something like that?
The only state I'm aware of that does not is Louisiana,
It's Louisiana. Yeah.
Yeah,
which is
I haven't looked at the California Constitution, but Western constitutions all arose, 1840s and after,
Right. Yeah.
and they're in some ways modeled after the U.S. Constitution, and
Right.
they don't take anything from the pre-revolutionary time.
Pre-revolutionary times. Yeah. So, but it makes perfect sense that the first Congress would, of course, be doing that, right? That's why it's in the Maryland Constitution. It's that was the thinking of people at the time.
Well, and
So,
that really becomes the in the last 15 pages, or not that much, last 7 or 8 pages of the majority opinion, that really becomes the bone of contention with Jackson, is that the analysis of the majority is consistent with long-standing precedent that the Judiciary Act of 1789 established the lower courts, and the statutory, or that the jurisdiction and authorities of the lower courts, not the Supreme Court, of the lower courts, come by way of statute. They are what Congress
right,
says they shall be. And
right,
so Congress in 1789 said that the federal courts shall have jurisdiction over suits in equity, and shall have the equity powers consistent with the, what was it, the High Chancery Court of England in
right,
1789.
right,
So as King said, this is how you do law.
right.
That's the statute where the courts were given their authority. There have been no subsequent statutes to expand or change the authority. So that's the source. You've got to find it there, or it doesn't exist.
Doesn't exist.
It is not the modern progressive approach that, well, we're just trying to do the right thing.
And we're a court, and we have court powers. Yes, you do, but your court powers are defined by the authority that gives rise to you being a court. Right now, you can't take that too far in the other direction. It's not the case that if nothing is literally in the Judiciary Act of 1789, the courts can't do it. They created courts under that statute. They gave them powers of equity as they existed with the High Chancellor, right? So it's courts. The word court has a meaning to it, but it's not an ever expanding, never ending, endless word at the same time.
Yeah, and her dissent ignores parts of the historical analysis that
Yeah.
Barrett does, where she just talks about, well, the king's prerogative and a government of kings. And Barrett said no. Barrett made the point that misses the point that the Chancery Court was created by the King of England to
Right.
take the responsibility for making equitable decisions. Those were no longer to be made by the crown. They were to be made by the Chancery Court, empowered by the crown.
Right. Pursue it to a regularized process
Right.
because the king didn't want to be bothered with all of
That's
that stuff.
exactly right. So in the U.S. Constitution, that power was given to the courts by the Congress because
Right.
we're not a kingdom.
Right. And we have courts and we need courts to do the court stuff. So there you go.
But it is,
yeah.
And I made this point in the article I wrote that she talks about the judicial checks on the executive, and it's like they're trying to hit her in the head with a hammer, saying, "Yeah, but this is a congressional check on the court."
Right. Right. It's the other way around, actually. Yeah, I know. Frustrating. Well, before we keep going with that, I want to make one side point here, which is this is an excellent. I agree with King. It's an excellent get by you, Ship, about this clerkship, because clerking is a very singular kind of experience. And I don't know if we've talked about this before. So I clerked. I actually clerked for one of the judges who is now on the District Court of Maryland. She was not at that time, but she is now. She's a retired. She's got senior status there now. Steve clerked for the 10th Circuit, and his judge was in Oklahoma. Did either of you clerk?
I did not.
I did not. I went straight into practice.
Okay. So when you clerk, you're helping the judge with all of their work. So doing all the stuff they're doing, which largely involves reading the briefs and drafting opinions, right? But like I have a better recollection of the cases that I helped my judge write than I do of some cases that I handled the last year that I practiced, right? Because it's such a formative experience. You've come right out of law school and you're just immersed in the law intellectually, and you're a young person usually, right? And like your mind is just filled with all these new legal ideas. And so I'm sure Amy Coney Barrett just knows that Guapo case backwards and forwards.
And
right. So that's just a fascinating development.
Knew Scalia's thinking.
Yeah. 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 So, okay. Well, so we're on to this case now, and it's been interesting to me that a lot of the mainstream reporting about the case, I think left and right, worse on the left in some ways, but even on the right, it's not super accurate, right? And I mean, even for lawyers, it's kind of a subtle argument, don't you think? This question about the universal injunctions versus the permanent injunctions versus striking stuff down under the Administrative Procedure Act, right?
Well,
it's just,
I would say there's no real forum for long form analysis to reach all of those issues at one time and sort of, make them understood, in relationship to each other.
right.
This is, I mean, I started, like I said in my Substack article I published earlier today, I resisted the temptation to just fire off some hot take articles yesterday because,
right.
well, as I read the majority opinion, and then you've got Thomas's concurrence and Kavanaugh's concurrence and Alito's concurrence, where the concurrences, raise three important or more important subjects. And it's like, well, why aren't these in the majority opinion? And it's like, okay, well, Alito is concerned about abuse of Rule 35 class actions just becoming a substitute. But, if you think about Roberts, the chief judge's approach to these things, his response would have been, this isn't a Rule 23 case, so why would
we'll
we
deal
talk
with
about
that when the Rule 23
Rule 23
case comes.
Right.
Right.
And so it doesn't make it in the majority opinion, but he wants to raise the issue in a concurrence, and Kavanaugh wants to
Right.
talk about, dealing with these on the emergency docket is something we probably should do
Right.
more often, not less often. Um, and and then it's like I'm not even going to try at this point to explore Judge Sotomayor's dissent. That thing's like 50 pages
Right.
long.
Right. I know. Right.
But
But
what was
and
great,
that's beyond even what I was saying, which is the issue that they actually decided is a subtle one. It was lost even on other lawyers that I talked to. That no, this is only about preliminary injunctive relief, whether it's TRO or preliminary injunction. This case is not telling us anything about what the district courts have power to do when they're making decisions on the merits.
yeah, it's almost like what is the organic source of this equitable authority? Does it really
Right.
exist?
Right.
And
Exactly.
if it does really exist, which it does,
Hmm.
are the circumstances in which it can be employed limited or as broad as the district judge's imagination might make it? And the answer was
Right.
limited.
Right.
Um, now,
So I think the easiest way for people who are not lawyers to understand this is what they decided is that a judge can issue an injunction to protect one of the parties in the case. It doesn't really matter which one, okay? In this case, it's plaintiffs. And the judge can issue an injunction that if he or she finds under the factors that an injunction is warranted, the judge can issue an injunction that protects that party in the jurisdiction where the judge sits and everywhere else in the country. So in that sense, any judge can issue a nationwide injunction to protect the interests of that party that's in front of that judge. But what's been happening is that the district judges have been issuing injunctions that protect not only the interests of the party seeking the injunction, but other people who similarly would be subject to whatever the new thing the government's trying to do is, because this is the context in which all of these arise, is that whichever administration has got the ball at the moment is issuing executive orders and changing policies and so forth. And so the judges have been issuing injunctions that prevent the government from imposing whatever the new rule is against the people that are in front of the judge, but also everyone else too. And that is what the court said, the what the Supreme Court said the district courts don't have authority to do. You guys want to add anything to that? I mean, that's basically what they actually decided. That makes sense because the rule, as I understood it, always was the court can give complete relief to the parties before it.
well, that is I mean, that's the historical. That's what going back to the High Court of Chancery.
Right.
That's what the analysis was. Is that the difference between equitable relief and legal relief, and I'll just this is broadly overstated, but I don't know. King might have said this the other night. The issue between legal relief is granting somebody damage.
Right.
The opposing party has wronged you, and to compensate you for that, they must pay you money.
Money.
That's a
Yep.
legal claim. An equitable claim is tell the offending party to stop what they're
To give
doing
me my stuff
or to
back.
do something.
Right.
It's not just compensating somebody for the loss. It's to affect their conduct in some way. Well, the, so equitable relief traditionally has been just the parties to the suit. What
Right.
what is fair while the case is pending? What and and the allegedly offending conduct is ongoing. Is it more fair to tell the offending party to stop or to allow the offending party to continue on by sort of taking measure of which side is likely to win,
Right.
making sort of an educated guess? So if the offending party is likely to win in the end, it is not fair to force them to stop. Whereas if the party being offended is likely to win in the end, it's not fair to allow the offense to persist while the case is pending.
Unless
So
you can reduce the offense down to money, and then you just have to wait and get your money.
right, right. So the equitable relief is traditionally and historically been between the two parties,
Right.
but
Then what
where
has happened is two things. One is the judges have started applying this paradigm, which works well when you have two private parties, to lawsuits in which the government is a party, which radically complicates it. And also, this power arises in 1789. Okay, fine. The Administrative Procedure Act is much newer than that. I can't remember when that was enacted. Steve knows this stuff off the top of his head, but you know, that act gives district court judges the authority by statute to vacate actions of the federal government, even in a preliminary injunction. And I think what has happened is that, especially with the judges in around the DC area, they have become very accustomed to, under the Administrative Procedure Act, telling the government, you have to stop this policy, right? You didn't do notice and comment. You didn't jump through all the hoops that you have to jump through in order to properly put this policy into effect. And so you must stop carrying it out. And
Let
I
me
think,
let me let me jump in.
go ahead, King.
What's going on here is Congress has stepped in, passed the Administrative Procedure Act, which outlines remedies that
Right,
the courts can grant. So
right,
you have a specific law that tells the court you can do this or you can do that to provide parties remedies when they're aggrieved. Equity, on the other hand, is totally judge written.
right,
There's nothing in writing by the Congress that outlines how far the courts can go to achieve equity or fairness.
right. Well, let me jump in and then I'll let you finish. The Administrative Procedure Act was signed into law in 1946. So this is a post World War II way of trying to, rein in or regulate federal agencies. The equity power goes back to the founding. But I just think, as a practical matter, the judges have lost sight of the fact that these are two different sources of authority for them. It allows them, as you're saying, King, to do things because the Congress has empowered them to. So this was one of the points that Justice Kavanaugh was making, right? Is that, and that did end up at the argument, and that did end up as a footnote in the majority opinion that that's a separate issue, that this opinion doesn't affect the Administrative Procedure Act situation at all. So that I thought was a very good clarification. King, did you want to keep going with that?
No, I'm done.
Okay. So, right. So with some caveats that it could potentially be done in a class action, right? There's other remedies under the Administrative Procedure Act. Um, the court, nevertheless, with this decision, I think has substantially reined in what the district court judges are going to be able to do. But I wanted people to understand, that's why I put out my sort of little list of things as it came out. Steve and I were reading it. We were doing the analysis quickly. Um, but, the Supreme Court is not saying that district court judges can never do these kind of injunctions, but it would have to be that the reason is because that's the only way to give the plaintiff that's in front of the judge, relief, which there's just not going to be that many situations where that would be the case. Ship, you agree with that?
I do when you consider the dichotomy of the backdrop of how do you bring a collection, no matter how large, of similarly situated individuals before the court at the same time?
Right,
And obviously, we get to, Rule 23 class actions. That's the formal way to do it.
right,
But, an issue that was raised during the oral argument and is reflected in I think it's in the majority opinion, is, that in effect, parties, plaintiffs have simply backdoored and gotten around the procedural requirements of a class action by simply asking for these nationwide injunctions, which have the same effect.
right,
You get on a preliminary basis what you are seeking in final relief that probably is more appropriately granted as part of a class action. You simply, and the judge gets to do it to impact thousands or millions of people who are never going to be parties. They're never
Right.
going to be members of the class because there is no class.
Right.
But by making use of preliminary injunctive relief, they in effect shut down the debate, so to speak. I've heard that. I heard some analysts make that point. That part of the analysis here. I didn't read it directly. I mean, it makes sense from a conceptual standpoint. Is when a single judge. And then I guess let's take the birthright citizenship case as an example. When the single judge, the 88-year-old Reagan appointee in Washington, grants a preliminary injunction on the birthright citizenship executive order and says this is patently unconstitutional. I can't believe any lawyer would go along with this. Well, that sort of shuts down the debate,
Right.
until that goes to the Ninth Circuit, and so part of the rationalization for taking this power, or dramatically curbing this power, is you actually want multiple judges on controversial issues doing multiple things, and then having those multiple cases head up to the circuit where there are multiple panels weighing in with their thoughts before it makes it to the Supreme
Right.
Court.
So a
Is
bunch
that
of
messy?
lawyers thrash through all the arguments
Yeah.
trying to get to the best ones.
Is it messy? Yes. Does it
Yeah.
create some uh, difficulties in application along the way? Yes. But at the end of the day, the belief is it produces the best considered decision making at the end of the line.
So let me ask you about both of you about two different issues that along this line. So the first is the Congress, some members of the Congress had, in response to these nationwide injunctions, proposed a legislation that would say basically that a district court judge's rulings would only be in effect within his or her district, right? Which could infringe on this ruling that the Supreme's just made. It would maybe limit a judge, prevent a judge even from giving full relief to a party in front of that judge if, in order to give the appropriate amount of relief, the order has to apply in California as well as Florida, right? So it wouldn't apply to everyone in the world, in the country, but it could apply to every place where this party in front of the court is being harmed. So the Supreme Court was careful to say, look, there's really two kind, we call them nationwide injunctions, but it's really two ideas. Nationwide is talking about the geography, right? Universal is talking about, does it apply to everyone, the entire country, in the sense of the citizenry of the country? And so I think would be a bad idea for the Congress to say, well, that a judge's ruling only has effect within that judge's district geographically. That doesn't make sense. But the other thing is, between that and this footnote in the opinion talking about the Administrative Procedure Act, that may have drawn the attention of some members of Congress to the fact that that act empowers judges to kind of do the same thing under a different authority, right? Federal district courts strike down federal agency actions all the time, especially in DC, and that under the Administrative Procedure Act, and that is effective nationwide by the district court, right? The government has to stop doing whatever it is they're doing. They can appeal it to the circuit. But so I wonder if this might not highlight in a way for the Congress that they might not, they might want to cut back on it further. What do you guys think?
Well, I agree that what you see in a lot of the cases that have arisen in the last 5 months against Trump administration, there seems to repeatedly be strains to squeeze APA causes of action
Yeah.
into the cases, and you have these cases for which are in effect for collection of damages, breach of contract, withdrawal of grant funding, cancellation of grants or
Right.
contracts, and you have the government's defense in many instances is that this is a claim for money under a contract, and then has to go to the Court of Federal Claims, and it's an exception to the APA.
Right.
And the plaintiffs and the judges, the liberal activist judges are doing everything they can to hold on to the APA claim, because the APA is the basis for an injunction
Right.
nationwide.
So,
So yeah, you could begin to see. Now it's going to run into the same problem. That is just, what can you get passed through a Congress that requires 60 votes in the Senate, and 47 Democratic senators are just you know destined to block any effort that they view as a benefit to the Trump administration. That's
right.
just a practical political reality of today.
Right.
So, are you going to get any kind of change to the APA through the Congress? And the likely answer to that is no.
Right. And I think they serve different purposes, right? The Administrative Procedure Act is specifically directed at preventing federal agencies from engaging in conduct or putting in policies without going through the appropriate hoops, right? Which, aren't that many actually when you really understand how it works. It's not that difficult to follow the APA. They just often don't do it. So, King, you want to weigh in on that?
I was about to say, good luck on getting something like that through Congress, particularly when even the smartest lawyers find themselves waist deep in mud.
Yeah,
Congress is not going to step in to fix that.
right. Right. But, it's the kind of thing where, okay, it seems like that's impossible now, but, some members of Congress could be thinking, well, we gave the district courts the power to do that. We should maybe take that back. Maybe we can't do it this term, but, keep that in mind. So, all right. Well, I thought the hue and cry over this thing in the liberal media was just absurd. It was like, the sky was falling
Well,
because,
for them it is, though, because this really strikes at the heart of the notion of the social justice warrior who transitions in the judiciary and becomes a progressive activist judge. This is the idea that they are not constrained by statutory limitations in the organic statutes that created the courts. They're only constrained by their do-goodness.
right,
That there should be no limit on their power, so long as their power is put to the force of good and not evil.
right.
And this strikes at the heart of that. And you can see that is just infused in Jackson's dissent.
Yes.
She's possessed by this thought that if you take the power to do good away from the judges, then you are simply encouraging evil.
Well, she doesn't put it in those terms. She says the judge is there to stop people from breaking the law,
Right.
which is
They should have the power to tell the president he has to follow the law.
the,
We
and
do have that
everybody
power.
else, anybody, no matter
Right.
what jurisdiction they have, no
Right.
matter what case and controversy
Right.
they have before them,
Right.
they have the ability, constitutional right and obligation to make sure everybody complies with the law, which is not our system of government.
Not
It's
is in
not.
the broadest sense, that's right. That's the judiciary's job, right? Is to say what the law is and tell people they have to follow it. But okay, but they do that within the framework that we have, within the structure that we have. And she's just cannot grasp that point. It's amazing. It's very Orwellian. I found her dissent somewhat terrifying.
I did too. It's scary. It is over the top, but it's if you talk, I suspect if you polled the press, I'd say 90% say she's right. A judge ought to have the right to tell everybody who's violating the law, stop it. You can't violate the law.
You know, it's,
I mean,
it's,
okay,
it's,
that's
it's
right
she
as
makes
far as it goes, but it's like so impossibly naive at the
yeah
same time.
she makes multiple references, and I'm working on a more of a sort of an
Mm,
in-depth analysis of just her misunderstandings of the court system is reflected in her comments. But she makes
Right.
references over and over again to a court doing this or a court doing that, and how that essentially is, that's the line in the sand. A court has said, don't step across it. And
Right.
so nobody can step across it. And there's an example, I think, that's in the majority opinion that talks about, it might have been in a footnote, that talks about, imagine if it were the case that a judge in Alaska finds a particular criminal statute to be unconstitutional, and the effect was that no other judge in any other district could allow a prosecution to go forward under that statute.
Right. No matter how wrong that judge in Alaska might be.
Exactly. But the rest of the judiciary and the Department of Justice everywhere could not prosecute a crime under that statute because it would be contrary to what a judge has said.
Right. And was it you, Ship, that was saying this, or were you just commenting on it? And I was agreeing on Twitter that she talks and writes like a district court judge, which is what she was, and she
I
was actually
I said
suitable for
that.
that, and
I
not for this.
I wrote that, and I've actually been asked to write an article on that, but it was based
Mm,
upon your commentary and then listening to her in oral argument.
yeah.
It was, and we have talked about this more than once, that she was 8 years on the district court bench in DC, a trial judge.
Right.
And I'm a trial lawyer, and you were a trial lawyer, and King was or is a trial lawyer. We are all intimately familiar with the exchanges between trial judges and the attorneys for the litigants. Okay,
Yeah.
that is not the way oral arguments before the Supreme Court happen.
Go. No.
Okay, but when you listen to her in oral arguments, you hear a trial judge
Yes.
interrogating the representative for one party or the other.
Yeah. Remember the argument where she said to the person, well, like the other side has the burden of proof. If we don't agree with your argument, that doesn't mean that they win because they have the burden of proof. I mean, I had to stop listening because there's no burden of proof in the Supreme Court. None. Zero. None.
Right.
Right? That's what you're doing as a trial judge, not as a Supreme Court justice. And it was just that's when the light went off for me. She has not graduated from her role as a district court judge to the position that she now holds.
Yeah, well, she had 1 year on the circuit court, but I think she only wrote 4 opinions.
Yeah.
I don't know how many. I mean, obviously, you don't write an opinion in every oral argument or case you participate in, but in that 1 year, she only drafted 4 opinions of the court, and then, and I made the point that as a trial judge, you make a lot of snap judgments where you don't have the time to go research and do analysis, and as a result, there are wrong decisions that get made.
That's why the courts of appeals were created.
But no trial is expected to be perfect. The only obligation is that the trial be fair, and that even trials that have errors in them can nevertheless be fair. But that's not the Supreme Court.
Right.
It's not like, well, your batting average is 80, 800. So you're only getting 2 out of 10 wrong. You're doing great.
Right. Oh well. Yeah. No, I know. So, and you can really see this same problem in this dissent. I think she genuinely cannot grasp this issue, this concept, that it doesn't actually make any sense that a district court judge, a single one or a handful of them, can tell the executive branch of the government, for every person in the country, you can't impose this policy because 2 people have decided to sue in the District of Maryland.
And you've made a preliminary judgment based upon limited facts and limited argument that they're likely to win.
Right.
Yeah.
Right. Because, you might be ever so wrong about that. The district court judges in this country make wrong rulings every single day. So,
well, did you see the I put up a post and then I doubled down on it with a little shot at our favorite private chef a couple hours ago. that I noted last night, that in fact, the same judge who issued the first birthright citizenship preliminary injunction
Mm,
denied the preliminary injunction to the parents in the Montgomery County Schools case.
right.
That judge went
Yeah.
0 for 2 in the Supreme Court yesterday.
Yes, exactly. That judge was having a bad week.
Judge Borden.
Yes. Another longtime public defender, I will say.
Biden appointee.
Um, yeah, Biden appointing. Again, another. She at least is a smart judge, right? Judge Zenas is a smart judge. Judge Boardman is also a smart judge. She went to UVA law, so. But
You know what though? But she clearly let her politics bleed through, because she denied
yeah,
those
of
parents
course,
a preliminary injunction when all they were asking for was tell the district to allow the opt out so that our children do not have to sit in the
right,
classroom when the
right.
only alternative we believe we have is to pull them out and pay
Pull them
private
out of
school
public
tuition.
school. Right, exactly. She could have given them that PI. That would have been actually, the status quo place to land, and then let the litigation move forward.
Right.
But no, she didn't want to do that because she was offended, right, that these parents don't want their children in elementary school taught about same sex relationships
Right.
and various other kinds of sexual expression. And I was reading that case today. That case is Mahmoud, for people who want to follow it, Mahmoud v. Taylor. And it's based solidly on the right of um, religious freedom, right? But it was interesting that the school board decided to impose that policy because they got so many requests to opt out, not from people who were basing it on their religious beliefs, but because they didn't want their elementary school children exposed to this because they thought they were too young.
Right. Well, and
And
and and,
that's
and
why
I
they
think
decided to shut down the opt
there
outs.
was a lot of discussion in the oral argument about, the attorney for the school board basically said the number of opt-outs were so great, we didn't have the staffing to
Right,
supervise the opt-outs and have instruction in the classrooms.
right. Which is absurd, actually, but okay. But maybe that should tell you that the community thinks if kids are going to be exposed to this, elementary school isn't the time to do it.
Right.
But
Oh,
that case is bigger than that. It it it's
oh,
it
I agree. But what
it
I'm,
really it really goes to the issue of what does First Amendment free exercise of religion mean, and how far does it go, and
well, see, I'm
where are
seeing that as a limitation because, there's all these other parents that don't want this either, not because they're practicing Muslims or practicing Catholics, but because they're concerned moms and dads. They want to be able to talk to their kids about that issue in their own time when they think their child is it's appropriate,
but this
right?
is a freedom of religion case.
That's my
That
point, is that it's a
yeah,
freedom of religion case, but we're probably going to have to expand, right, that idea into a broader First Amendment right, and the right's going to go nuts about this because it's like a penumbra kind of concept. But I've always thought that basically you have a right to not have the government tell you what you have to teach your child in the realm of morals, values, right? Normative behaviors, right? And that eventually we're gonna, I don't know, have to amend the Constitution or pass a statute or something to say that that extends beyond just the idea of religious liberty.
I agree, but just for so everybody understands
The actual case, yeah. Go ahead.
the case, and I learned some things. Uh, Maryland is 50 over 50% immigrant now.
Montgomery County,
Montgomery County is,
yeah,
and uh, over 50% of the population of that county speaks another language at home as their primary language.
right.
And this case was brought by a Muslim family
And a Catholic family.
and there was an African
Mm.
I forget what religion, but they, uh,
Well, okay,
but
okay.
they,
Now, let's come back to that, King. But I got to mention one more thing. We'll just hold that. The collection of plaintiffs here was clearly um,
Orchestrated.
orchestrated, because I think
Yeah.
the one you're talking about, King, the African American, it was a single mother with a special needs child who would only get the special educational benefits for her child in the public school. If she withdrew her child over this concern, she would lose those benefits. All right, good. So I
yeah,
just
and
they collected very sympathetic
Right.
plaintiffs.
With clear lines. Yes.
yeah, and the whole theme was the parents' right to an ability to teach their kids their religion
Right.
un, unobstructed by the public school. And what was going on at the public school was kind of brainwashing.
Well,
Best way I can
they
say it.
called it disruptive.
Yeah.
They called it the purpose was to disrupt traditional teachings.
Right.
Exactly, and they through such techniques as if teacher, if you are questioned by a student about concepts like what's a man, what's a woman, uh, anything that criticizes the doctrine of LGBTQ plus, uh, you know, the response should be, if you take the other side of that, it's hurtful.
Right.
It
It's
hurts
harmful.
people.
Right.
It's hurtful. Uh, make them embarrassed and shameful that they have another view, and that very posture really undermines the parental ability to teach their kids their religion that says otherwise, that says there are only two sexes, that sort of thing.
Right.
I almost,
Right.
and I haven't read the whole opinion. I'm about halfway through it, so I can't speak to everything Justice Alito said. But I kind of read a sort of almost like a mirror image analysis or mirror image doctrine there, which was it was a challenge and accepted and approved by Judge Justice Alito, a challenge to the concept that the state is entitled to dictate through compulsory education a certain standard of values or morals that it believes should be taught.
Right. And others that should be discouraged.
Right. That
Yeah.
the
And this is where
objecting parents were interfering with that governmental right through compulsory education to instruct in that fashion. That's I kind of read it that way. It's like, okay, asserting free exercise of religion. That's the textual the textual
tie.
assertion of
That's the
right,
tether.
but
Yeah.
what it is going after is the concept that the government has some entitlement, that the county of Maryland or the Maryland County Schools were entitled to do this because they refused to allow parents to opt out. And they said this is compulsory education. If your child is not here, it's an unexcused absence, and parents can be punished for unexcused absences.
Right. Yeah. So they got you coming or going. Right. But that's why I'm saying it. The case is literally free religion, but it reads more, and it needs to, because we need to establish this for no kidding and for damn sure, that it's actually more like freedom of conscience, right? It's a freedom of speech corollary type idea that you have the right to teach your children what to believe, whether it's tethered to religion or not.
Freedom of conscience, that it struck a nerve for me because this is one of the issues. This is the issue in my early days that made me decide to become a lawyer.
Mm.
I had a class in college, first year of college, uh, where we studied an active freedom of religion case, United States versus Clay, which was then percolating through the lower courts. It ended up in the Supreme Court. Uh, I don't know if anybody caught that, but Clay is Cassius Clay, also known as Muhammad Ali.
The greatest.
And he had been convicted of draft dodging and sentenced to 5 years in prison and had to give up his heavyweight title in 1967. He had won that title in 1964. Greatest fighter ever. There's no question. And one of my heroes. And uh, he had asserted conscientious objector status when he was drafted, and the administrative agency in charge of the draft rejected it. Courts, and then he was prosecuted for draft dodging, and they took the issue up to the Supreme Court on the issue of free exercise of religion, because he said he did it on the basis of his new black Muslim Nation of Islam
Faith, right.
faith that held, he claimed, and he believed that wars were immoral and against God, unless they were jihadi. That's the only war he would acknowledge
Mm.
that was allowed, and the Vietnam War was not that. So the issue became: was this a selective uh, uh, ex- use of the religious conscientious objector defense to being drafted, or was it seriously based on a universal principle within the religion, that the faith that he held? And it went all the way up to Supreme Court, and he ended up winning. But in my term in 1968, the final exam was to write a brief to the Supreme Court for or against his position. And when I did that, I decided I've got to be a lawyer.
Oh, that's fun. Well, it does strike me that there will be plenty of people in this country, as we become as a nation less religious in many ways, who will nevertheless think, I don't have a problem with same-sex marriage, as I personally don't. I have zero problem with that. But that maybe my 6-year-old doesn't need to grapple with that yet, right? Maybe I'm going to wait until he's 11, right, to talk to him about that. Or maybe I'm going to wait until organically one of his friends, has two fathers, and then we'll have that discussion, right? Or whatever. And that's not based on religion, but based on people's assessment of when is it appropriate for their child to grapple with these issues. But then the government just is going to tromp all over and say, well, no, everybody's kid has to start dealing with that in kindergarten. That seems insane to me.
I think there's a difference between the religious
Hmm.
element of that and the parental
Right.
rights part of that.
Just straight up parental rights. Right.
Parental rights, I think, is political.
Yes, it
Religious is in
is.
the Constitution,
Right. I
and
agree.
that's a major difference.
Right. It's a major shortcoming, in my opinion, because we then have to shoehorn all of these kinds of cases into uh, the freedom of religion, bucket. And then you get into questions like we did with the vaccine issues with the COVID, of who then is going to decide whether this is, a la your story about Muhammad Ali, a genuine expression of religious belief. Who gets to decide that? The people that don't want you to do the opt out in the first place, right? And it just encourages people to say, okay, well, this is my religious belief, when it's not. Do we want that, right? Simply because they want to opt out for their own personal reasons, or ethical reason perhaps, or a conscience reason. You're right. It just creates a whole bunch of problems. And so I wish we would just handle it more honestly and say, you know what? The school system just has no business teaching children that, period.
Uh, I agree. It in a perfect world that would be the case, but we live with our Constitution as written. I don't think
Yeah.
it's really hard to get it changed,
Yeah.
particularly get it broadened.
Yeah.
So
I know, but this is an area where it's like, because
so
it is exactly what you said. It's brainwashing by the government.
it absolutely is. I mean, those storybooks that you. By the way, that opinion is really worthwhile
Hmm.
read because it actually gives you the uh, uh, the 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 books that they're talking about, the books that they're using to teach these kids, uh, these younger kids, like early grades,
Right.
uh, about not only how to read and write, but also how to believe and to act and to perceive the world. And nowhere do you see or hear anybody teaching kids about X XX chromosomes
Right.
and
Right. Right. See,
XY
that's
chromosomes,
where I'm
and
going. That's
the
where I'm
the
going with this.
science part of it,
Right.
it's all feelings. It's all, they're teaching kids that it whether it's a boy or a girl that comes out of mother's womb at birth it's a guess as to whether it's a boy or a girl.
Well, but that's where I was going with this, because as a woman, it's like, okay, the government gets to brainwash the next generation that these trans people are women when they're not, they're men, right? Which I think is the grossest violation of women's rights in my lifetime. Right? The abortion thing is its own thing, but this idea that men can transform themselves somehow into women and be in the ladies' room and play sports and girls' sports and whatever, I think is obscene, an obscene violation of women's rights. And if the government, on what religious basis are if we have to proceed under the freedom of religion rubric to challenge that, that's not going to work.
Well, I mean, what about science? It 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 sets science back centuries.
Right. So it bothers me from a less religious based. I see the religious argument. I respect that argument. I know plenty of people who, for them, that is the most important point. But I also see that there are a lot of people in this country who are not as religious as that, for whom this is still a problem. And it's always a problem to me when the problem centers on the government telling people what they should say, what they should think, what they should believe. All of those things should just not, they should just all be off the table in our constitutional republic.
Well,
So,
and the some of the details that are in that Maryland, curriculum,
yeah.
just and again, you talk about 5, 6, and 7 year olds that that they are expressly told by their teachers in trying to explain transgenderism that when you're born, your parents just guess at your gender
Right.
based upon your body parts, but that you might feel differently when you get older. I mean, if that is not just, you know, an ideological mindset that has zero scientific
Well,
basis.
and directly undermining their parents' authority
Exactly.
in their life. Yeah.
Right. At 5 years old, your parents just guessed that you were a boy,
Right. Right. They might
and
be
they might
wrong.
have been wrong.
Right.
Right.
Well, it's actually more than that. They are. It's the government policy s- steering young impressionable kids into uh, down a road that could ruin their lives.
Right.
You know,
Right. Some percentage of them, that's exactly what's happening. Of course. Right. We're talking about people who have parents who are trying to shield them from this. What about the kids who don't have that? So, Well,
It's none of the government's business
exactly.
is
That's the
the
bottom
answer.
line. That's the bottom line.
And the Supreme Court dealt with it under a uh, freedom of religion
Yeah,
rubric,
right.
but and
Well, because that's the way the case was postured. But the problem is that the law points you that way because we haven't developed another theory for it.
well, there's a political end of this. I mean, uh, way to look at this. With the number of immigrants from around the world of recent vintage, uh, the Muslim population in the U.S. has grown significantly,
Mhm.
and there's one religion I think that is most opposed to the woke ideology, and I would say that's Muslim.
Yeah. Yeah,
Uh,
they have
and
very
and
traditional uh,
they are
concepts. Yeah.
traditional. They do not move in their beliefs very far. So uh, it was inevitable that this was going to come up.
Yeah, that would be a clash.
Eh,
Yeah. Well, so we're gonna have to work on that stuff. Is the bottom line. Um, but going back to the injunctions case, so both those cases came out the same day, the last day that the court issued opinions, and they issued some other cases that day too to wind up the term. One of which was a tax case that Neil Gorsuch wrote a beautiful dissent on. I'd encourage people to read that if you're a lawyer or you're just interested in legal things. His style I find to be just very attractive. He's so clear, so direct, so it's so easy. He makes complicated issues very easy to understand. So he's my favorite justice. I think I'll just say he's the most libertarian of the group. Of course, I gravitate to that, but he did a good job in this tax case. Was there any other of the decisions that came out that day you guys thought was interesting enough to talk about?
there was one opinion, I forget the name, that went Trump's way as to who he can fire. It was
Oh
one of
yes.
those sub agencies where uh, the the appointees contended that they were kind of immune from being fired willy nilly at will by the president, and Supreme Court pretty gave that pretty short shrift.
Right.
They said you are an inferior officer of the executive branch. You are therefore you are at will. You can be fired, and you have no right to your office.
And we're going to sanction your lawyer that made this stupid argument. No, actually, that didn't happen. That's not what they said. But that leads back to Ship's point that because that case and this national injunctions case is really going to roil, I think, those cases about um, who can the president fire without much process or not, because there's a bunch of injunctions in those cases too. And then back to Ship's point about how this particular judge who did the national injunction on the school case we were talking about, they went back to her yesterday. Today's the 28th. Yes. So the Supremes issued their opinion on Friday, and the their lawyers went back to the district court the same day and amended their complaint. Um, and filed a motion to certify a class and asked for another emergency TRO.
Yeah, that's the birthright citizenship claim with Judge Boardman,
Boardman. Right.
who also did the Montgomery schools case. But
Right.
it's in the birthright citizenship case that they went right back in,
Right.
added a class action cause of action, asked for TRO, and she's already set a hearing on the TRO for Monday.
Monday. Yeah.
Now, I'm not sure. I haven't done a Rule 23 analysis, but it strikes me that those are likely to end up as class actions. You have you clearly meet the numerosity requirement.
Right.
I,
You have a common factual claim, a common legal question. Now, there may be some subclasses that you would have to identify, based on, parentage and, other kinds of issues that there may be variables in, the how the determination of birthright citizenship would or would not be made. I mean, they're all born in the United States because that's the basis of their claim on birthright citizenship. But the executive order, excludes some on certain factual bases. So you might have, different subclasses, but I'm not sure how you would handle that. I'm not sure how you would oppose a
Well, I have
class
never done a
designation in that
class
case.
certification because thank God I didn't do a whole lot of civil litigation. So I don't have anything intelligent to add about this. But I
Mm.
suspect King does, though.
Yeah, and I agree with Ship. I think this one is will end up as a class. The only issue is who's going to be the class representatives, who are going to be the class lawyers. That class litigation, as a practical matter, uh, the big issue always turns on who are going to be the lawyers because they're the ones that make the money.
Right.
Well, and
So Justice,
this will also
go
go
ahead.
to a different realm. You already have three cases filed in three different districts, and each judge has already issued a preliminary injunction. So I expect that the other two districts, at least, will also have class actions filed in the modeling themselves after the one in Maryland. You could end up with multiple class action cases on the same subject in multiple districts, which then leads you to the multiple district
District
class action
litigation
process,
process, which is a whole other
where
section in the rules of civil procedure.
exactly. And just without going into a lot of detail, what happens is there's a panel that decides which district should have all the class actions, and they all get located in one district with one judge.
It,
So you
it,
can
and,
have
and that, as I said, that turns on who who's going to be which law
Which
firm or
lawyers?
group of
Right.
lawyers
Which lawyers?
have the most strength, the most
Pull in that
pull,
case,
the
yeah.
most
right,
pull
right.
with both the district judges as well as the multi-district panel that decides where it goes. Because
Right.
where it goes uh, pretty much drives who the lawyers are going to be.
Yeah, and that and so just but just for everybody who's listening who doesn't know anything about this subject, there is a process for handling this.
Right.
If these three cases all become three different class actions in three districts and more are filed in other districts, there is a process for all of those to end up in one place with one judge in an orderly fashion and then proceed under the rule.
Right. And then you just get one shot at the circuit in that situation. Is that right?
Correct, because in the other districts, the cases are no longer pending. They've been moved. The venue has been transferred.
Okay. All right.
And
So,
and it in the end of the day, it works. It really does work.
right. It works for when lawyers all across the country are bringing the same kind of claims on behalf of a bunch of people. So you see this in
Correct.
bad drug cases and, medical device cases and
Exactly. Mass
poisoning
torts.
cases, mass torts, right. The courts have grappled with how to simplify this. Also because they don't like people getting different results all over the country for basically the same thing. Um, yeah. So it's a stab at trying to get some consistency and
Or
efficiency.
or defense verdict in one district and a
Right. It's
liability
all
judgment
over
in
with.
another.
Yeah, right. Yeah, right. Right. Disparate kinds of outcomes. So, yeah. Okay. Well, did you guys have any other points you wanted to make about this national injunctions case? I mean, as King said, it's kind of like a totally nerd out thing for lawyers.
Yeah.
Um, and it's gotten caught up in the political divisiveness, which has made it a hot button issue for non lawyers. But in general, I think the majority opinion is well reasoned. I think the result they got was right. Kavanaugh certainly is correct, I think, in his concurrence that it's going to cause the courts of appeals and the Supreme Court to have to get more involved in preliminary injunctive matters. But that's probably a good thing.
Well, I think probably what's going to happen, and we might want to revisit this in 2 weeks, is I think you're going to see a flurry of orders come out to begin to sort this issue out in individual cases. You're going to see remands for further
Yeah,
proceedings consistent with this opinion. They're going that I think in some of the motions for stay they will give some guidance, but they're going to ship them back to the district judges and say try again.
right. One
And
of our peeps had asked the question of, will the government have to make a motion in every one of those cases saying, hey, I want you to dissolve the injunction?
well, I think probably what will happen is at the in the district court in cases where they haven't actually appealed or the appeals are pending, you might see motions for reconsideration. You might see, based upon the comments of the Supreme Court, the preliminary injunction sweeps too broad, and that the preliminary injunction should be modified to only apply to the parties before the court and not all similar. You'll see that in a lot of the grant cases where it's like, okay, these 10 grantees have sued us and they want their money. And you're ordering us to pay them, to continue paying them while the case is pending, but don't order us to pay another 500 grantees who aren't even in court,
Right. So the
which is what they've
practical
done.
answer is it's not like automatic, right? Even when the Supreme Court strikes down a statute as unconstitutional, right? It, the lawyers bring that to the attention of the court. The courts themselves don't say, "Oh, hey, that order that I issued 3 weeks ago, it's unconstitutional now."
Right, right. The lawyers have to, start the ball rolling with
Yeah,
suggestions as to what needs to change.
yeah. But it's not like, well, there could be some cases where people just try to fight it. There's always that, right? It's like these lawyers in Massachusetts. They're really repping their client well because they just file so one thing after another. So, and sometimes you do get that. But in general, the the government's not going to have any trouble getting these nationwide injunctions dissolved because very few of these district judges, I think, are going to be like, yeah, well, I'm just not doing that. I don't care what the Supreme Court says.
Well, I'm suspicious. I think some of them may simply say, they are committed enough to the cause. The judges are committed enough to the cause to engineer themselves around what they think the hurdles are. And I would say, as an example, is Judge Reyes there in D.C. and her injunction on the transgender
Yeah,
members in the armed
the
services.
military. Yeah.
She is a partisan in every sense of the word.
Well, I said
Um,
very many. I didn't say none of them.
no, I
Right.
understand, but
Yeah. Some of
I
them
think
clearly will be knuckleheads and fight it
yeah,
out.
no,
But
but they have, the litigants, the plaintiffs have picked their jurisdictions very carefully.
yeah,
They have true believers on the bench in many of those cases.
right. That's where it got filed. So let me see if there's any other questions for us. You guys
You
got
got
anything?
another example would be that the judge up in, I think it's Judge Whitehead up in Washington. The Ninth Circuit keeps telling him he's wrong, and he keeps saying, "Well, okay, I'm a little bit wrong, but I'm going to go focus on this
But
other thing."
not really, right?
Yeah.
Yeah. Good grief. Let's see. Let me see if this is a question. Oh, that's more like a comment. Um,
What was the other one? Judge Ali there in D.C. who gave the government 48 hours to pay out $2 billion.
right. Yeah. Right. It's ridiculous. So, let's see. This is this a question? Oh, this person's pointing out an error in Justice Sotomayor's citation
I saw that
to.
noted earlier. Somebody
Yeah.
called that out.
Yeah. That's interesting. There are often errors in Supreme Court opinions. I mean, they're not works of divinity.
Yeah,
Um,
it strikes me it's like a historical text, and somebody
yeah,
looked at it and said that's not there, but a similar comment is in another sort of related text,
yeah,
and
exactly.
it kind of
From
that
that
struck me
extent.
as this is a clerk's error where they
Yeah,
saw a quote with a citation, they pulled that out, and that source material has got it wrong.
right. Yeah, I think so too. Yeah. I mean, there's one case in the Supreme Court that dealt a little bit with my specialty practice area. So wasn't about clearances per se, but it was about certain kinds of access that people needed to get onto federal grounds. It was less than clearance, okay? But the Supreme Court opinion reads like someone wrote this. I forget which justice it is, who didn't know anything about this area of the law because they didn't. Like there's things in it that are totally wrong. Like it's not at all the way what the form says. It's not at all the way it actually works in practice at the agency. It's just like totally wrong. And it's like when you read an article in the newspaper about something that you know and understand very well, and you realize how much reporters mess things up.
Oh yeah.
And then, but you're reading the rest of the paper like they know what they're talking about. And I have the same experience with the Supremes then because I know how bad they messed up that case that was in my specialty area. So I'm never shocked when there's like mistakes in their opinions.
I always used to. I would get a kick when I was a prosecutor, and I had some case that was getting press attention,
Yes.
and sometimes you would hear, oh, they're going to do a story on your case at 5. Turn on the TV.
Uh
And so
huh.
we'd go into the conference room and turn on the TV, and you'd watch the reporter. So
Yep.
I always had some sympathy for the reporter that the live news reporter for when the little red light went on, they had to have something to say. And
Right.
I used to tease them. I said, you know what? I I'm generally accepting if you're like 50% right. If you're
Right.
only 50% wrong under the circumstances, you did a good job. It's
You met the mark. Right. Because the reporting from courthouses by reporters is abysmal. It's awful. It's almost always like substantially wrong in some respect. But okay, they're not lawyers so most of the time. They don't know. So, but unfortunately, it misinforms the public. So the Supremes is the same way. They don't get everything right because they're human beings. They get stuff wrong. So, all right. Well, I think probably enough for this evening. It's good to talk to you both. Um, so folks know King and I are going to be doing, it sounds like two of these now, King, right? On the JFK
Uh,
paper.
Up to you. Yeah,
Yeah.
anytime.
I think you wanted to do one that's sort of like setting up, background, and
Yeah.
then another night we'll do like your actual thoughts and conclusions.
I could do 10, but I'm gonna have to cut it short.
Yeah. Well, at that point, we need a budget from Netflix or somebody
Yeah.
to do it. So,
Yeah.
Ship, do you want to join in on those, or will you bow out of those?
I am probably going to bow out because I have never really looked at the subject in any depth, and I would have zero to add. Whatever King says, that that's got to be it.
Right. I don't know a ton about it either, so I'm just going to play the role of interviewer, and
I
then
mean, I've got my opinions, but it's everything is controversial.
yeah.
So questions are encouraged, and Chip, I'd like your 2 cents too, if you're interested.
Well,
Yeah.
when the day arrives,
Yeah, right.
once I know
We'll
the
have to figure
schedule,
that out on the calendar. I would like for Steve to be involved in it too, because he was a young man when Kennedy was killed. So, he's more interested in it really than I am. Um, but because you know how it is, things that happened before you were born, you were like, okay, that's history. Um,
yeah,
but
I was 2.5, so
yeah,
I was 2.5, so my recollection is a bit foggy.
yeah. The major thing that shook up my generation was the Challenger explosion. That happened when I was a senior in high school. And then, the Berlin Wall fell when I was in college. So those are like the defining moments of my generation. But, for Steve and King, it's Kennedy and the Vietnam War, right? So
Yeah,
makes the
JFK, MLK.
Yeah.
RLK, and then the Vietnam War,
Yeah.
and
And Nixon. Yeah.
they kind of meld together
Right.
into at least some of us boomers, an attitude.
Right. Yeah. Yeah. So okay, well we'll pick a date for that, and we'll do those, and then we're gonna be picking up with these. It's about 8 cases now. I still have Senator Padilla on our list. What's the over under on whether he's going to get charged? Ship.
Well, my view is he should be charged, but I
Yeah.
suspect that they may not want to pick a fight in a chamber with only 100 members. They have business to do in the Senate that's important.
Aha. Okay. Which some people, this takes me to another issue. Some people are starting to ask the members of the House, hey, you guys threw George Santos out when he was charged, but before he got convicted. So why is Congresswoman MacGyver still in the Congress?
No, I agree. Except the meaningful distinction I think there is that they had done an ethics investigation
Yeah.
of Santos,
Yeah, they wanted to get
and
rid of Santos.
much of Santos's fraud was essentially fraud on the voters that led
Yeah.
him to
Yeah.
be elected in the first instance.
Yeah.
Um, campaign finance fraud and a lot of other similar kinds of things that went right to how he got there.
But
Um,
see, this is the problem when you say the reason is one thing and it's actually something else. Because they said the reason was that he'd been, seriously charged. So, substantively, charged, even though he wasn't convicted, it was, enough because he'd been officially charged or whatever. Okay. Well, you said that's what the standard was.
no, no, I understand that, but they had the benefit of an ethics committee report.
Yeah. But
All
they
they've
weren't
got
going to
with all they've
expel,
got
they
with
weren't going to
all they've
expel
got
him
with
on that.
all they've got with. Oh, I think they would have. I think they would have. All they've got of MacGyver though is the video and her statements.
Yeah.
It's not much. Not much to work with.
It's not much to
It,
go on.
it,
Plus the
that
testimony of those cops that were there getting manhandled.
my view is they have so little time and to do what they need to do in Washington,
Yeah.
compared to how much they need to do outside
Yeah.
Washington to campaign, raise money, and go on vacation
Yeah.
around the world.
Yeah. Johnson's
Yeah,
got
it
bigger fish to fry than that.
so you can expect at most in almost every case a censure, and even that's hard to get.
Well, do you think that'll be the case if she gets convicted or pleads guilty?
Oh, if she gets convicted and pleads guilty, she's out.
Okay.
Yeah,
All right. So maybe they're just waiting it out.
that's it. They before they can't jump before they find out where it's headed.
Yeah. Well, but they did for Santos, and I understand why. I'm just saying, okay, but this is what people ask this question because you guys have said the reason was he was, credibly accused and charged. Okay. Well, we all saw what the congresswoman did, so it bothers me when public officials say things like that. Oh, this is what the standard is, and then
Well, yeah,
everyone can see
but
that's not
I think that,
not what's going on.
but I think the reality also is, and you're right. I think the reality also is that a majority of the Republicans wanted Santos out, and
Right,
all of the Democrats wanted Santos out.
right,
Whereas they will never get the Democrats in any number to go along with getting MacGyver
right,
out, and they need a two-thirds
right,
vote.
right. Exactly. It's not possible to do. Is the actual real reason.
Right.
Right. So, right as usual, it's theater only is what we're doing here. So, all right, guys. Well, thanks again. It's good talking to you both. I think we'll say good night for tonight.
Right. Good night.
Good night, all.